Hi, I'm attorney Ben Schwartz, and I'm going to tell you a story, and then I'm going to talk about the law behind it. Matt Brown and Hannah Reese were on vacation in August of 2015 in Rehoboth Beach, Delaware, with their two children. They visited Nicola Pizza for dinner, but the young family was turned away because their son, Colton, was in a special medically adaptive stroller that helps him breathe, cough, and take nourishment. Colton suffers from spinal muscular atrophy. The hostess would not seat the family because the restaurant had a no strollers policy, no exceptions. The dad, Matt, later called the restaurant and spoke with Nick Caggiano Jr., the son of the founder, and according to the article on Delaware Online, Caggiano simply laughed when Matt mentioned the Americans with Disabilities Act, or the ADA, which prohibits discrimination on the basis of physical disabilities. For more information on that story, click on the link that's embedded in the blog post, the written blog post, at schwartzandschwartz.com, and it'll take you to Delaware Online to that story. This is an equal accommodations case. This type of thing happens more frequently than you would imagine, and in my practice I've seen several cases. I've been on the defense side where I've represented the business that is alleged to have discriminated against someone, and I've also been on the other side representing someone who's disabled who has brought a complaint against a business for denying equal accommodations or equal access. If you're a business owner in a business that serves the general public, the last thing that you want to do is deny somebody equal accommodations due to a protected classification such as race or such as physical handicap or disability. And if you are the owner of a business and someone in your business, one of your employees does this, I would suggest that the last thing you want to do is be in Delaware Online or the News Journal laughing about the violation of the law. The cases that I handled were not filed in federal court as ADA, American Disabilities Act cases. Instead, they were filed in the state of Delaware under the Delaware, the DEAL, the Delaware Equal Accommodations Law, and they were filed before an agency of the state of Delaware called the Human Relations Commission. If you look in the written blog post for this, I included a link to Title VI Delaware Code Chapter 45, which is the DEAL. This Delaware statute prohibits discrimination by places of public accommodation against any person due to race, age, marital status, creed, color, sex, physical disability, sexual orientation, gender identity, or national origin. And the law specifies that discriminatory practices include refusing, withholding, or denying accommodation, facilities, advantages, or other privileges. Under the DEAL, a customer who is discriminated against has the right to file a complaint with the Human Relations Commission. The Commission can conduct a settlement conference, which is called a conciliation, or they can have a public hearing. And if there's a public hearing, the hearing panel, the Human Relations Commission hearing panel, can award compensation to the person who was discriminated against. Interestingly, they can also award attorney's fees. So there's really no reason for someone who believes they were discriminated against not to go and seek legal counsel about the situation. There is a very short period, the very short statute of limitations period under the DEAL. In most cases in Delaware, the statute of limitations will be 2 years or 3 years, but not in these cases. there's a 90-day statute of limitations. If you don't get your complaint filed with the Human Relations Commission in 90 days, you're done. The case is over. Interestingly, I talked with one of the other attorneys in my firm, Joe Stanley. He told me that he's a Pennsylvania attorney. He told me that the Pennsylvania version is pretty similar to the Delaware version. There's a Pennsylvania Human Relations Commission website, and you can check out the Pennsylvania Equal Accommodations law there. Some examples of denials of equal accommodation. I'll give you an example of a deaf patient who's denied reasonable accommodation at her dentist's office. The deaf patient contacts the dentist's office and inquires about American Sign Language interpreters, and the dentist's office refuses to make any sort of accommodation to help the deaf patient. Another example would be a blind passenger who has a guide dog, and then the blind passenger goes to get a taxi and is told, "Oh, I'm sorry, you can't get in this taxi with your dog." Another example would be a black patron, African American patron, who goes to a Denny's restaurant and is denied service, or who is made to prepay for his meal. And in fact, some of you out there may actually remember this, because in 1994 the United States Department of Justice sued Denny's, and the lawsuit was because of discriminating against African American patrons in that way. There was a $28 million settlement, and in the notes, in the blog, the written blog content, you can click a link and go to a PDF document that contains the settlement agreement in that case. In any event, if you're a business person, I think it's good to know about this law, about the Equal Accommodations law, because you want to stay on the right side of the law. And if you are a citizen in the community, it's good to know about the law, because it never hurts to be a well-informed consumer of goods and services. And so my name's Ben Schwartz. If you have any questions about this video, if you have any comments, the best way to give us your thoughts and feelings is to go on our Facebook page, facebook.com/Schwartz&Schwartz, and leave a comment there. Thanks very much. I appreciate you watching this video. I hope you found it enjoyable, entertaining, and informative.